For some brand new breaking news, MS Now has just learned that FBI Director Kash Patel may be out of a job in the coming months. 3 people with knowledge of the situation say President Trump and his top aides have grown tired of Patel and the unflattering headlines he's been generating recently.
I've never been intoxicated on the job, and that is why we filed a $250 million defamation lawsuit. And any one of you that wants to participate, bring it on. I'll see you in court.
The head of America's most powerful law enforcement agency just filed a $250 million defamation lawsuit against one of the country's most established news magazines, and on the same day that lawsuit was announced, a separate news organization reported that President Trump himself may already be considering replacing him. So here is the question that every legal analyst, every journalist, and every American watching this story is now asking: can Kash Patel actually win this case? Not emotionally. Not politically, but legally, under the actual law that governs defamation cases in the United States. Does this lawsuit have a realistic path to victory? Because the answer to that question is far more complicated than anything you have heard in the headlines. And by the end of this video, you will understand exactly what this case requires, what the evidence shows, and why the outcome matters for every American regardless of which side of this debate you are on. Stay with us. This is where the real story begins.
Beat their drums and stand next to toxic waste all they want, but that doesn't make it toxic waste. And Maria, I'm happy to announce on your show that we are not going to take this laying down. You want to attack my character? Come at me. Bring it on. I'll see you in court.
So you're going to sue them?
Absolutely. It's coming tomorrow.
Tomorrow you will be dropping a lawsuit against the Atlantic magazine.
Yes, I will, for defamation. And because you know what, Maria? We have to fight back against the fake news. It's one of the many things that President Trump is so successful at in leading out on, because no one is attacked as baselessly as he is and as much as he is. And our leaders that get attacked under his brilliant leadership must do the same. And I won't tolerate their attacks on me, because they are indirect attacks on the men and women of the FBI that we've cleaned up. And this historic, prolific year of crime reduction across the board is something that all Americans should be. And I know they're proud of it, because I travel across the country and they say our communities are safer than ever before.
In American defamation law, there is a 62-year-old Supreme Court ruling that governs every case where a public official sues a news organization for something they published. That case is called New York Times versus Sullivan. It was decided in 1964. And it established the single most important legal concept in this entire lawsuit: the actual malice standard. Here is what actual malice means in plain English, because this is the exact legal test Patel must clear to collect a single dollar of his $250 million claim. Because Kash Patel is a public figure, the director of the FBI, appointed by the President of the United States, he cannot win this case simply by proving that the Atlantic got something wrong. He must prove one of 2 specific things. Either the Atlantic knew the story was false when they chose to publish it, or the Atlantic published the story with reckless disregard for whether it was true or false, meaning they had serious doubts about the accuracy of the claims and published anyway. That is a legal bar that is specifically and intentionally set very high. The Supreme Court designed it that way in 1964 to protect press freedom, particularly when journalists are investigating and reporting on powerful government officials. And that brings us directly to the heart of this case, because both sides have very different stories about what happened in the hours before that article went live. Patel's attorney, Jesse Binnall, argues that the Atlantic was warned, specifically, clearly, and in writing, before publication that key claims in the article were false. That the magazine had been given factual corrections. And that it chose to publish regardless. If that argument can be proven with documented evidence in federal court, that is precisely the kind of conduct that satisfies the reckless disregard standard. The Atlantic's position is the direct opposite. Their reporter sent 19 questions. Neither government agency disputed anything. The sourcing involved more than 24 credible insiders. And their editorial process met every professional standard. A federal court will now have to determine which version of those pre-publication events is accurate. But there is another dimension to this case that has received almost no serious coverage, and it may be the most legally significant factor of all. Stay with us. Because this next part changes everything about how you understand this lawsuit.
I say that I am a very careful, very diligent, award-winning investigative reporter with a history of award-winning work across multiple organizations. You and I, in fact, have worked together previously. I stand by every word of this reporting. We have excellent attorneys, and it is a surprising statement, but a very telling statement, I believe. And I would also note, we reached out for comment to the White House and to the Justice Department, neither of which disputed anything. We gave multiple opportunities, including 19 detailed questions. So we stand by every word. And look, this is telling because there are so many people. You alluded to it earlier. These are not the types of people who are willing to speak out outside of the FBI, especially right now, because Kash Patel is going after people with polygraphs in a way that has never happened at the Bureau. So for it to be this level of alarm, this is people genuinely concerned that America is in danger as a result of this conduct. And I feel, a real responsibility to take care of that reporting incredibly carefully. And The Atlantic is nothing.
You just heard Sarah Fitzpatrick say something that deserves its own full explanation. Quote, Kash Patel is going after people with polygraphs in a way that has never happened at the Bureau. That is not just an institutional claim. That is a legally significant piece of context, and here is exactly why. According to corroborated reporting from multiple news organizations, Director Patel ordered polygraph examinations for more than 24 members of his own FBI staff. The reported purpose of those polygraphs was to identify who among his employees had been speaking with journalists. Think about what that means for a moment. If the head of the FBI was conducting what multiple outlets described as an unprecedented internal loyalty investigation, specifically targeting potential media sources, that creates a situation where any source willing to speak to a reporter was doing so at enormous personal and professional risk. Legal analysts have pointed out that this context actually strengthens the Atlantic's credibility argument in court. Sources who risked being identified through a polygraph program and still chose to speak, and to speak to multiple reporters who independently corroborated each other, carry significantly more weight than anonymous sources with no verifiable risk profile. Patel has not publicly confirmed or denied the polygraph reports. His office has characterized reporting on internal FBI management decisions as part of a broader political campaign against his leadership. But here is where this becomes directly relevant to the lawsuit itself. In American civil litigation, when a defamation lawsuit survives early dismissal, and many do not, both sides enter a formal legal process called discovery. Discovery means that each side has the legal right to demand documents, communications, and sworn testimony from the other party. For Patel, discovery means his legal team gets access to the Atlantic's internal editorial communications, emails, notes, source contact records, every internal discussion related to how the article was researched, written, edited, and published. But discovery works in both directions. The Atlantic's legal team would simultaneously gain access to FBI internal records, administrative communications, security logs, scheduling documents, and potentially sworn testimony from current and former FBI officials regarding the specific conduct alleged in the article. Read that again slowly. A lawsuit filed to challenge reporting about conduct inside the FBI, if it proceeds to discovery, could legally compel FBI officials to testify under oath about the very conduct the lawsuit disputes. This is the single most significant strategic risk in Patel's legal approach. And it is a risk that experienced defamation attorneys on both sides of the political spectrum have publicly identified. Legal scholar Adam Steinbaugh of the Foundation for Individual Rights and Expression was among the most direct in his public assessment of the lawsuit. He stated that the actual malice allegations in the complaint, as written, face an extremely high hurdle, describing the bar Patel needs to clear in court as one the complaint does not currently approach. Patel's attorney pushes back firmly on that assessment. Jesse Binnall has stated publicly that The Atlantic acted with clear editorial bias, failed to take basic investigative steps to verify its claims, and was warned before publication that the central allegations were factually false. Both of those arguments will now be tested in federal court. And here is the broader legal context that puts this entire lawsuit into clearer perspective. This case is not happening in isolation. In 2025 and 2026, multiple defamation actions have been filed by or connected to the Trump administration against major American media organizations. Suits have been filed or announced against the New York Times, CNN, the BBC, and the Des Moines Register, all in relation to coverage that administration officials or the president described as unfair or false. A complaint filed by President Trump against the Wall Street Journal was dismissed by a federal judge earlier this year, though potential refiling has not been ruled out. Legal scholars refer to this category of litigation by a specific term, SLAPP suits. Strategic lawsuits against public participation. The term describes legal actions that critics argue are designed less to win in court and more to accomplish secondary goals, creating legal costs for news organizations, consuming editorial resources, putting pressure on journalists and their confidential sources, and sending a public signal that critical coverage will result in litigation. First Amendment advocates argue that even a lawsuit that ultimately fails in court can create a chilling effect on investigative journalism, particularly at smaller organizations that cannot sustain prolonged legal battles without financial strain. Defenders of these lawsuits argue the exact opposite. That American journalism has operated for decades with insufficient legal accountability for false and damaging anonymous source reporting, and that the courts are the correct venue to establish that accountability. Here is what is important to understand. Both of those arguments reflect genuine constitutional tensions. And the law as written does not fully resolve them. That is precisely why cases like this one ultimately reach federal courts. But before we get to what actually happens next, there is one more layer to this story that almost no coverage has addressed. And it changes the entire picture of what Patel is actually facing. Beyond the courtroom, there is an institutional dimension to this story that affects every American regardless of their political views. The FBI's effectiveness depends heavily on public trust that operates in multiple directions simultaneously. Agents in the field depend on community cooperation to do their jobs. Whistleblowers and informants depend on confidence in the institutional integrity of the bureau they are speaking to. And America's international security partners depend on confidence in the stability and professional focus of the FBI's leadership. A prolonged public legal battle, involving allegations of personal misconduct at the director level, regardless of whether those allegations are ultimately accurate, creates what former senior intelligence officials describe as institutional drag. Resources that should be focused on the Bureau's operational mission get redirected toward legal proceedings, media management, and internal morale issues. Multiple retired senior law enforcement officials have noted publicly that any significant period of leadership uncertainty at the FBI, for any reason, creates vulnerabilities that adversarial state actors are specifically trained to identify and exploit. That concern exists entirely independent of whether this lawsuit succeeds or fails in court. There is also a separate political dimension worth examining carefully. MS Now's breaking report, the one that opened this video, stated that 3 people with direct knowledge of the situation told their reporters that President Trump and senior White House aides had grown tired of Patel and the unflattering headlines his tenure was generating. The White House has not officially confirmed or denied that characterization. But if that reporting is accurate, and it was presented as sourced from multiple direct contacts, it introduces a timeline variable that makes every other aspect of this legal situation dependent on one question. How long does Kash Patel remain director of the FBI? Because if Patel is removed from his position before this lawsuit concludes, for any reason, the legal picture changes significantly. A former FBI director has different standing in court than a sitting one. The political context of the lawsuit shifts. And the narrative surrounding the case changes entirely. That is not speculation. That is standard legal reality. And it is a dimension of this story that requires direct acknowledgement. So let us now walk through the 3 realistic paths this lawsuit is most likely to take. Scenario 1, early dismissal. The Atlantic's legal team will almost certainly file a motion to dismiss immediately after being served with the complaint. This motion will argue that the lawsuit fails to establish actual malice on its face, that even taking every allegation in the complaint as factually true, the legal standard for a public figure defamation case has not been met. Federal courts dismiss defamation suits filed by public officials against established news organizations at this stage with significant frequency. This is statistically the most common outcome in cases of this type. If the court grants dismissal, Patel's team would almost certainly appeal, but the litigation would effectively end at the trial court level. Scenario 2, confidential settlement. If the motion to dismiss is denied and the case enters discovery, both sides face significant exposure. The Atlantic faces the possibility that its internal editorial communications are examined and potentially become public. Patel and the FBI face the possibility of sworn testimony from current and former officials about the conduct the lawsuit disputes. In this situation, a private settlement becomes increasingly attractive to both parties. Settlements in high-profile defamation cases are typically confidential. Neither side fully wins or loses in the public record. This outcome preserves both parties' ability to claim a form of vindication. Scenario 3, full trial. This is statistically the least likely outcome. But it is also the most consequential. A full trial would potentially make every piece of evidence, every deposition, every internal communication from both the Atlantic and the FBI, part of the permanent public record. The legal precedent set by a trial verdict in a case of this profile would influence how American courts handle similar cases for years. Legal experts across the political spectrum are currently divided on which of these three paths is most likely. That division itself tells you something important: this is not a settled or predictable case. Before we get to the final verdict on this lawsuit, there are 5 things that most coverage has either gotten wrong or left out completely, and each one matters. First, many people believe that if the Atlantic's story contains any false information, Patel automatically wins. That is incorrect. Under the actual malice standard, a story can contain errors and still be legally protected if the publisher made a good faith effort to verify information and had reasonable grounds for believing it was accurate. The law protects honest mistakes. It does not protect deliberate falsehoods or reckless indifference to the truth. Second, many people believe that using anonymous sources automatically makes a story legally vulnerable. That is also incorrect. American courts have consistently upheld the legitimacy of anonymous source journalism, particularly when sources face documented risk for speaking, as Fitzpatrick specifically noted in her public statement, given the Polygraph program allegedly in place at the FBI during this period. Third, many people believe that $250 million is what Patel is actually likely to receive if he wins. That is not how defamation damages work. Courts evaluate actual harm to reputation and demonstrable financial loss. Punitive damages are possible in cases of proven actual malice, but the final awarded amount in defamation cases routinely differs significantly from the amount initially claimed. Fourth, many people believe this case will be resolved quickly. It will not. Federal defamation litigation of this complexity typically takes between 2 and 4 years to reach a conclusion, assuming no early dismissal. This is a long-term legal process. Fifth, and this is perhaps the most important misconception. Many people believe that whoever wins this case, the result will be a clear moral verdict on whether Patel is fit for duty or whether the Atlantic acted responsibly. Courts do not deliver moral verdicts. Courts apply the law as written. A Patel victory would mean the court found the Atlantic met the legal definition of actual malice. It would not be a finding that every claim in the article was false. An Atlantic victory, or a dismissal, would mean the court found the legal standard for public figure defamation was not met. It would not be a finding that every claim in the article was true. Understanding that distinction is essential to understanding what this case can and cannot tell us. So, with all of that established, here is the most honest, fact-based legal assessment of where this case stands right now. The actual malice standard creates a structural legal challenge for any public official suing an established news organization. That is not a political statement. It is a documented reality of American defamation law that has applied to plaintiffs from both political parties consistently for 62 years. The Atlantic's documented process, 19 specific pre-publication questions, no disputed factual elements from either the White House or DOJ, more than 24 sources operating under documented personal risk, provides meaningful legal protection against a reckless disregard argument. The discovery risk cuts both ways. The Atlantic's internal editorial records are exposed. But so are FBI administrative communications, scheduling records, and official testimony about the conduct at issue. The strongest component of Patel's case is the pre-publication warning argument. If his legal team can produce specific, documented evidence that the Atlantic received written corrections and ignored them, that argument becomes significantly more competitive under the actual malice standard. The weakest component of the case as filed, according to independent legal analysts who have reviewed the complaint, is the framing of actual malice itself. The complaint, as initially written, does not appear to clearly establish the documented evidence of knowing falsehood or reckless disregard that the law requires. That does not mean the case is without merit. Legal complaints are amended. Evidence emerges during discovery. And courts have occasionally found actual malice in cases where publishers were given specific pre-publication corrections and chose not to incorporate them. But based on the public record as it exists today, the legal burden rests significantly more heavily on Patel than on The Atlantic. Here is the bottom line. Kash Patel filed a $250 million defamation lawsuit against The Atlantic. The lawsuit is real. The court case is real. The legal stakes are real. But the question we started with, can he actually win, has an honest answer based on established American law. It is possible. But it is legally difficult. And it requires Patel's team to clear one of the highest evidentiary bars in American civil litigation. The actual malice standard exists for a reason. The Supreme Court established it in 1960 for not to protect false reporting, but to ensure that powerful public officials cannot use the legal system to suppress accountability journalism simply because they find it damaging or inaccurate. That principle applies whether you agree with the reporting or not. Whether you support Patel or not. Whether you trust The Atlantic or not. The law does not ask those questions. The law asks one question only. Did the publisher know the story was false, or act with reckless disregard for whether it was? That question will now be answered in the United States District Court for the District of Columbia. And the answer, whatever it turns out to be, will help define the boundary between press freedom and press accountability in America for years to come. There are 3 things to watch as this case develops. Watch whether the court grants an early motion to dismiss. That ruling will tell us whether a federal judge believes the complaint even meets the legal threshold to proceed. Watch whether any pre-publication communications between Patel's legal team and The Atlantic become part of the public record. That evidence is the single most important variable in determining the strength of the actual malice argument. And watch what happens to Patel's position at the FBI itself. Because the legal trajectory of this case changes significantly depending on whether he remains director when key decisions are made. We will track every verified development in this case as it moves through the federal courts. No speculation. No editorial opinion. Just the facts as they are established and confirmed. That is what AVA Reports is here to do. What do you think? Should American law make it easier for public officials to sue news organizations? Or does the current standard protect something that is essential to a functioning democracy? Let us know in the comments below. We read every single one. If this video helped you understand the real legal story behind this lawsuit, please hit the like button. It helps more people find accurate, fact-based coverage of stories like this one. Subscribe to AVA Reports and turn on the notification bell so you never miss our next breakdown. Thank you for watching.